All right. Everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is the verdict unanimous?
Yes.
All right, if you'll hand the verdict form to the deputy, please. Thank you, Deputy Lauren. All right. If the defendant can rise. Count one, aggravated sexual assault of a child. It says, we, the jury, find the defendant, Jesse Inaho, not guilty of the offense of aggravated sexual assault of a child as charged in count one of the indictment. Count two, to the offense of decency with a child by sexual contact. It says, we, the jury, find the defendant, Jesse Inaho, guilty of the offense of indecency with a child by sexual contact as charged in count two of the indictment. You may be seated. Would anyone wish to have the jury polled? All right, so ladies and gentlemen, what's going to end up happening is I'm going to have you go back to the jury room and then we'll start up with the next phase of the trial. All right, everyone, please rise for the jurors. All right, are both parties ready to proceed with punishment?
Yes, Your Honor.
Yes, Judge.
All right, Deputy, if you'll line them up and have the jurors come in. That's okay. Yes.
All rise for the jury.
All right, everyone, please be seated. All right, State, do you have any opening statements for punishment?
State would waive opening.
Defense, any statements?
No statements, Judge.
All right, State, any witnesses?
No, Your Honor, but we do offer all evidence and testimony from the guilt innocence phase.
All right, defense?
We do have one witness, Judge.
All right, you may call your witness.
We called Daniela Hinojo.
All right. All right, if you'll take a seat, please, and raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Be sure to keep your voice up so that the members of the jury and the court reporter can hear. If you'll state your name for the record.
Daniela Anisa Inoho.
Defense.
Hi, Daniela. I understand you're sitting there not at a time you expected to be sitting there. Where do you live?
I live in Edinburgh, Texas.
In Midland, Texas, and are you married?
Yes.
Who are you married to?
Jesse Inoho.
Okay. Do you have any kids?
Yes, we have 2 boys.
How old are they?
I have a 7-year-old. We have a 7-year-old and a 1-year-old.
Do they have any, before I go there, I'm sorry. Have you ever been convicted of a felony?
No.
Do you have much family support where you live?
Yes. Well, like where I live in Edinburgh?
Correct.
No, it's just my mother-in-law and my sister-in-law. Those are my main support.
Okay. What do you do for a living?
I'm a stay-at-home mom currently. I watch the kids, as you know, the little ones.
So you're a stay-at-home mom. Is it fair to say that Jesse was the breadwinner?
Yes.
And what did Jesse do for a living?
He works in the oil field. He works in the cement department.
Does he make enough to support y'all without any
Yes.
extra aid?
Yes.
Now, you understand what has happened here in terms of the conviction with Jesse?
Yes.
Okay. And is it your testimony to this jury that you would request the jury give as lenient a punishment as possible?
Yes.
Pass the witness, Judge.
Any questions?
Yes, just a few. Ms. Hinojo, has Jesse ever been convicted of a felony?
No.
And are you aware of what community supervision is,
I don't understand.
or probation by another term.
Yes,
Um. That what you're asking for your husband to get? Or are you asking for as lenient a prison sentence as possible?
I mean, as lenient as possible.
Now, you said you have a 7-year-old and a 1-year-old, correct?
Correct.
If something like this happened to them, what do you think an appropriate punishment would be for the perpetrator?
You want my honest opinion? I feel like if this was back then, yeah, definitely. I feel like in today's world, there's a lot of unsaid and what needs to be said. And I just feel like today's world is just very different. That's as far as I'm gonna go.
Ask the witness.
Let me ask you a couple questions because I get the understanding. I might have confused you, and that's completely my fault. So I want to make sure we're totally clear and with what the state said. With the conviction on count 2, there are several options. One would be prison or a term of imprisonment, and one would be probation.
Correct.
Okay. Of the two, a prison term or probation, if it's granted,
Probation.
you would prefer probation?
Yes.
Would you ask this jury for probation?
Yes.
Would you ask this jury to give a sentence of 10 years or less so Jesse would be eligible for probation?
I don't understand.
Okay. In order for someone to be eligible for probation, the underlying sentence has to be less than a certain amount of time.
Okay.
Are you asking the jury to sentence Jesse to less than 10 years so he could be eligible for probation?
Yes.
I'll pass witness.
No further questions, Your Honor.
All right, you may step down. Defense, call your next witness.
Defense rest.
State.
Rest and close, Your Honor.
Defense, do you close?
We do.
All right, ladies and gentlemen, that is all the evidence you're going to hear with regards to this phase of the trial. I'm going to ask you to go back because there are a couple of things that I need to have prepared for you before I allow you to deliberate. You're not allowed to start deliberating on punishment or discuss anything about this case again until I give you leave to do so. Does everyone understand? All right, everyone, please rise for the jurors. All right, everyone, please be seated.
It's totally.
It's okay. I really thought, I was like, yeah, it's fine.
She pulled the audible, no problems. But yeah, but you see.
Things were just like, I actually completely forgot about that. I mean, technically, if I was 12, that's I didn't love me. Okay, when she was young.
And counsel, once the charge is brought down, I give you a chance to make your full objection on the record after reviewing the charge.
Yes, ma'am.
But whatever you want. But that's true. Yeah. Do you feel? You don't think so? What's after that?
April 9th.
April 9th.
Is what?
Brandon Wright.
Stay something.
That's what the
day.
following
Keep on that.
I wouldn't allow that.
And that's amazing.
That's
Yeah,
a
that's what you
career.
have to know.
That's an ugly.
You said there's something. It's-
Mary Diaz. Is it in May?
No,
It's not too long.
I know, I thought things were changing for you. Yeah, changing for you. Well, I guess they are meant not to chase. You are too done.
I think I really
All right, to the jury. Please be seated.
Ladies and gentlemen of the jury, I'm going to read you the charge of the court on punishment. Members of the jury, by your verdict returning count 2 of this case, you have found the defendant, Jesse Inaho, guilty of the offense of indecency with a child by sexual contact. It is necessary that the jury assess the punishment for this offense. 1. You are instructed that the punishment for indecency with a child by sexual contact is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. Therefore, you will assess the punishment of the defendant at any term of not more than 20 years or less than 2 years. In addition to imprisonment, an individual found guilty of indecency with a child by sexual contact may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim, if any, but it is paid into the registry of the court. The defendant in this case has applied on written sworn motion for community supervision, stating among other things that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of the offense of indecency with a child by sexual contact, where the victim of the offense was not younger than 14 years at the time of the offense, and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision, it will be granted by the court. If there is any evidence before you that the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, you're instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe, beyond a reasonable doubt, that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act or everyone, just one moment. Parties approach. All right, we're back on the record. Ladies and gentlemen, the last paragraph I was reading to you about if there is any evidence before you that the defendant may have previously committed offenses or acts of misconduct, that should have not been included in the charge, so you are to completely disregard that. Does everyone understand? And when the charge is sent back with you, that page will not be in the charge. Does everyone understand? You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law might be applied to this defendant because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is here to attach for your verdict if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Are parties ready to proceed with closing?
Yes, Your Honor.
All right, you may proceed.
State will reserve.
Defense.
Ladies and gentlemen, thank you for your time and service. Mr. Graham. It's tough. This is always the hard part for a defense attorney. Also one of the most important parts. Testimony that you heard, Jesse's wife, she's a stay-at-home mom. Jesse is the breadwinner of their family. She takes care of her kids. Accordingly, we respectfully request you consider any term of punishment on the lower range of the scale. As the judge said, scale of imprisonment is anywhere from 2 years to 20 years in prison. We respectfully request any term to be 10 years or less. We would request a recommendation.
State.
Thank you, Judge. Please the court and defense. We're here at the end of a long road that started in 2018. You guys are gonna have this verdict form to go back to you, kind of talk you through everything, what you're gonna first decide before anything else is on a prison term. Regardless of whether you want to consider probation or not, that's where you gotta start. Now, as we've discussed, it's anywhere from 2 to 20 years. It's a wide range, like we talked about in jury selections, because she didn't know the facts at the time, and there's different types of facts. This is not a 20-year case, and I'm not gonna say it's a 2-year case. I like to recommend that you start in the middle, start at 10, and then talk to each other and ask yourself, what makes me wanna give more, but what makes me wanna give less? And kind of start that way. You can talk about anything you learned or heard about during guilt, and you can take into consideration anything that his wife said here. You can consider all of these things. So after you've done that, you'll write that here on this first line. Then you'll decide whether or not you want to assess a fine. Just to reiterate, if there is a fine assessed, it doesn't go to Christina or her family. So you can also just not do one. Yeah. The important part is if you believe that Christina, when this was committed, that she was under the age of 14, he doesn't get probation. If you believe that she was 14 or older, then he can. And then you would address it down here. If you want probation, you would do this bottom one, and then just kind of read all the options. It walks you through everything. Kind of read your instructions carefully. But as we know, from Jesse's own testimony, from Christina's testimony, from Lupe's testimony, the time that he lived at the house was when she was 12 years old. It was 2018. She was 12 years old. So we are asking for you to sentence him to prison. Thank you.
All right. Deputy Laura, you may take the jurors back. And ladies and gentlemen, I'll have the jury charge sent back to you. All right, everyone, please rise for the jurors.